My name is Amy December, and I am a Senior Research Associate in the Office of Research and Data at the United States Sentencing Commission. On December 12, 2025, the Commission voted to publish proposed amendments to the United States Sentencing Guidelines, including a proposed amendment on drug offenses. The Commission is seeking public comment on the proposed amendments. This presentation provides data analysis to inform the public's comment on the proposed drug offenses amendment. This proposed amendment contains three parts, Parts A, B, and C. The Commission is considering whether to promulgate any or all of these parts, as they are not mutually exclusive. Part A of the proposed amendment sets forth two options for amending the drug trafficking guideline at Section 2D 1.1 to address the purity distinction between methamphetamine in actual form and methamphetamine as part of a mixture. It would also amend Section 2D 1.1 to address offenses involving ice. Part B of the proposed amendment would amend Section 2D 1.1 to respond to the enactment of the Halt All Lethal Trafficking Fentanyl Act, or the Halt Fentanyl Act, which permanently scheduled fentanyl-related substances. Part C of the proposed amendment would amend Section 2D 1.1 to add new enhancements for offenses involving fentanyl and fentanyl analogues. First, we will review data related to Part A of the proposed amendment, which addresses the purity distinction between methamphetamine in actual form and methamphetamine as part of a mixture. Part A of the proposed amendment sets forth two options for amending 2D 1.1 to address the purity distinction. Both options aim to update the guidelines manual treatment of methamphetamine to reflect the evolving nature of methamphetamine trafficking, while addressing the concerns that animated Congress's decision to set mandatory minimum penalties for certain methamphetamine trafficking offenses. Part A would also amend Section 2D 1.1 to delete references to ICE and add a new specific offense characteristic at Section 2D 1.1 that provides for a two-level reduction if the offense involved only methamphetamine in a non-smokable, non-crystalline form. In fiscal year 2024, cases sentenced for methamphetamine made up almost 1/2 of all federal drug trafficking cases reported to the Commission. Drug trafficking cases sentenced for methamphetamine had the longest average sentences among all drug trafficking cases, with an average sentence of 96 months. 1/3 of methamphetamine trafficking cases were sentenced for methamphetamine mixture, 57% were for methamphetamine actual, and 11% were sentenced for ice. In cases where methamphetamine mixture was tested for purity, court documentation indicates that the substance was uniformly highly pure, at more than 90% pure on average. This slide shows the average guideline minimum sentence and average sentence imposed in methamphetamine trafficking cases. The average sentence for methamphetamine mixture was 83 months. The average sentence for methamphetamine actual was 101 months. The average sentence for ice was 107 months. First, we'll look at option 1 for Part A. Option 1 would set the same quantity threshold for all methamphetamine offenses. Option 1 would delete all references to methamphetamine actual from the drug quantity table at 2D 1.1c and brackets 4 alternatives for the quantity thresholds for methamphetamine. Quantity thresholds matching the current quantity thresholds for methamphetamine mixture, quantity thresholds matching those of fentanyl, quantity thresholds matching those of cocaine base, and quantity thresholds matching the current quantity thresholds for methamphetamine actual. Next, we'll examine how many individuals would be impacted by the 4 bracketed alternatives in option 1. Specifically, we'll present information on how many individuals sentenced in fiscal year 2024 would have a different base offense level had the amendment been in effect. As a reminder, in fiscal year 2024, 1/3 of methamphetamine cases were sentenced for methamphetamine mixture, which is represented by the people in dark blue, and 2/3 of methamphetamine cases were sentenced for meth actual or ice, which is represented by the people in lighter blue. Each figure represents approximately 100 persons. We'll use this graphic throughout the discussion of Part A to show what percentage of individuals in each group would have a change in their base offense level from the one that applied in their case. If the Commission were to set the drug quantity threshold at methamphetamine mixture for all meth traffickers, then no individual sentenced under the guidelines for methamphetamine mixture would be impacted, and 100% of the individuals sentenced under the guidelines for methamphetamine actual would have a change to their base offense level that applied in their case. In total, about 5,000 individuals would be impacted, and their base offense level would be set at the lower methamphetamine mixture levels. If the Commission were to set the drug quantity threshold at methamphetamine actual for all meth traffickers, then 100% of individuals sentenced under the guidelines for methamphetamine mixture would have a change to the base offense level that applied in their case. No individual sentenced under the guidelines for methamphetamine actual would be impacted. In total, about 2,500 people would be impacted, and their base offense level would be set at the higher methamphetamine actual levels. If the Commission were to set the drug quantity threshold at the thresholds in the middle matching fentanyl or cocaine base, which generally are lower than those for methamphetamine actual and higher than those for methamphetamine mixture, then the base offense level for all meth traffickers would change. While there is overlap on the ranges in the drug quantity table that could affect whether an individual's base offense level changes when set in the middle, when considering the outer bounds, this is a net change of about 2,500 more individuals with their base offense level set at a lower level. This slide summarizes the impact of option 1 using a single entry for methamphetamine and how it would affect the 1/3 of current cases where the base offense levels are set at the methamphetamine mixture levels and 2/3 of current cases where the base offense levels are set at the methamphetamine actual or ice levels. If the Commission were to set the quantity threshold matching the current thresholds for methamphetamine mixture, then 100% of cases would be set at a methamphetamine mixture base offense level. If the Commission were to set the quantity thresholds matching the current thresholds for methamphetamine actual, then 100% of cases would be set at the methamphetamine actual base offense levels. If the Commission were to set the quantity threshold in the middle at levels that match the current quantity thresholds for either fentanyl or cocaine base, then all methamphetamine cases would be set at points between the current base offense levels for methamphetamine mixture and actual. Option 2 of Part A would maintain different base offense levels for methamphetamine offenses, but establish those levels through an assessment of both the quantity of the drug involved in the offense and other conduct-based factors. First, Option 2 would set a baseline quantity threshold for methamphetamine at a level between the current quantity thresholds for methamphetamine mixture and methamphetamine actual. This option brackets setting the baseline quantity threshold for methamphetamine at the same level as those for trafficking offenses sentenced for cocaine base. Second, if certain conduct factors applied, the initial base offense level established by the quantity of the drug in the case could be reduced to current levels, base offense levels for methamphetamine mixture, or heightened to the current base offense levels for methamphetamine actual. Option 2 has bracketed alternatives for 1, 2, or 3 or more factors that the court could have to find before reducing or heightening the base offense level based on quantity. Under this option, the Commission could require a different number of factors to be found before the reducing or heightening provisions applied. Option 2 provides the factors that would reduce or heighten the base offense level. The reducing factors are: the defendant did not receive any enhancement under subsection B1, B2, B5, B12, or B14 of section 2D 1.1, or under section 3B 1.1 or section 3B 1.4. These factors shown in the green box act as one reducing factor. That is, for these reducing factors to apply, an individual cannot have received any enhancements. If an individual receives any one or more of these enhancements, then the reducing factor would not apply. Other reducing factors are: the defendant received the safety valve reduction under subsection B18 of section 2D 1.1. The defendant received a mitigating role adjustment under section 3B 1.2. The defendant was motivated to commit the offense by an intimate or familial relationship, threats, fear, serious coercion, blackmail, or duress, and was otherwise unlikely to commit such an offense. The defendant was unusually vulnerable to being persuaded or induced to commit the offense due to a physical or mental condition, including drug dependence or abuse, or the defendant's youthfulness at the time of the offense. The defendant committed a single criminal occurrence or a single criminal transaction that was committed without significant planning, was of limited duration, and represents a marked deviation by the defendant from an otherwise law-abiding life. The heightening factors are: the defendant received an enhancement under subsection B1, B2, B5, B12, or B14 of section 2D 1.1. The defendant received an aggravating role adjustment under section 3B 1.1, or the adjustment at section 3B 1.4 for using a minor to commit a crime. The defendant knowingly distributed methamphetamine to an individual that was under 18 or 21 years of age, or the offense involved the distribution of methamphetamine to an individual that was under 18 or 21 years of age. The defendant used or possessed, or the offense involved the use or possession of, a pill press for the purposes of manufacturing methamphetamine. And the defendant used, or the offense involved the use of, the dark web to facilitate the commission or concealment of an offense involving methamphetamine. Some of the factors are specific offense characteristics or adjustments currently in the guidelines manual, while others are factors not found in the manual. In this presentation, we will only be presenting data related to the factors that are already in the guidelines manual. In cases with both reducing and heightening factors, Note A to the drug quantity table states, if a mixture or substance contains more than one controlled substance, the weight of the entire mixture or substance is assigned the controlled substance that results in the greater offense level. Thus, in cases where both reducing and heightening factors are present, the heightening factors would trigger and result in a heightened base offense level. This means that if an individual has both heightening and reducing factors, only the heightening factors would apply, and the base offense level in that case would be set at the meth actual level. First, we'll examine how often reducing and heightening factors are present. One or more reducing factors are present in 60% of methamphetamine cases. One or more heightening factors are present in 40% of methamphetamine cases. Again, in cases where both reducing and heightening factors apply, the heightening factors would trigger and a heightened base offense level would be applied. In this data analysis, individuals with both heightening and reducing factors are included only in the heightening factors group. All of the individuals in the reducing factors group did not have any heightening factors. All individuals sentenced for methamphetamine trafficking in fiscal year 2024 had at least one reducing or one heightening factor. Next, we'll look at all of the individuals with reducing factors. As a reminder, this group does not include anyone with heightening factors. There were about 4,900 individuals with one or more reducing factors. If the Commission were to require that one or more reducing factor apply, then 100% of these individuals would have a base offense level established using the methamphetamine mixture quantity thresholds. If the Commission were to require two or more reducing factors to apply, then about 1/2 of these individuals would decrease to the meth mixture base offense levels. If the Commission were to require 3 or more reducing factors, 1/4 of individuals would decrease to the meth mixture base offense levels. Now we'll look at only the individuals with heightening factors. As discussed previously, while some of these individuals may also have reducing factors, their heightening factors would trump and cause their base offense level to be set at the meth actual quantity levels. There were about 3,300 individuals with 1 or more heightening factors. If the Commission were to require that only 1 heightening factor apply, then 100% of these individuals would have a base offense level established using the meth actual quantity thresholds. If the Commission were to require 2 or more heightening factors apply, 1/4 of individuals would increase to the meth actual base offense level. If the Commission were to require 3 or more heightening factors apply, 5% of individuals would increase to the meth actual base offense level. Next, we'll examine how many people would be impacted by option 2. Specifically, we'll present how this option would have changed where the base offense levels were set in methamphetamine cases sentenced in fiscal year 2024, and the effect this option would have on the ratio of cases using methamphetamine mixture quantity thresholds compared to those using methamphetamine actual quantity thresholds. Because the Commission could require different number of reducing and heightening factors apply, there could be a variety of combinations for this option. For ease of understanding, we will use the same number of reducing or heightening factors in this presentation. We will show these comparisons when 1, 2, or 3 reducing or heightening factors are present. First, we'll look at the impact if the Commission were to require 1 or more reducing factors and 1 or more heightening factors for option 2. 38% of meth mixture cases involved 1 or more heightening factors, so about 950 individuals would be impacted and increased to a meth actual base offense level. The remainder of the meth mixture cases involved at least 1 or more reducing factors and would remain set at the meth mixture base offense level. 60% of meth actual and ice cases involved 1 or more reducing factors, so about 3,000 individuals would be impacted and decrease to a meth mixture base offense level. The remainder of meth actual and ice cases involved at least 1 or more heightening factors and would remain set at meth actual base offense levels. The net overall change for this option would be a decrease in the base offense levels for just over 2,000 individuals. All individuals had either reducing or heightening factors. Therefore, if the Commission were to require 1 or more factors for both the reducing and heightening provisions to apply, no one would have a base offense level established by the cocaine base quantity thresholds, which are in the middle between meth actual and meth mixture. If the Commission were to require 2 or more reducing factors and 2 or more heightening factors for option 2, here is how the base offense levels would change from how they applied in fiscal year 2024. Among those individuals with methamphetamine mixture, 10% had 2 or more heightening factors and would increase to the meth actual base offense level. 58% did not have at least 2 reducing factors or 2 heightening factors. As a result, their base offense level would be set at the cocaine base quantity levels, which are in the middle between meth actual and meth mixture levels. The remainder had 2 or more reducing factors and would remain at the meth mixture base offense level. The overall result would be that about 1,700 individuals with methamphetamine mixture would have a higher base offense level than currently applied in their case. Among those individuals with methamphetamine actual or ice, 34% had 2 or more reducing factors and would decrease to the meth mixture base offense levels. 55% did not have at least 2 reducing or 2 heightening factors. As a result, their base offense level would be set at the cocaine base quantity levels, which are in the middle between meth actual and meth mixture. The remainder had 2 or more heightening factors and would remain at the meth actual base offense level. The overall result would be that about 4,500 individuals previously sentenced using meth actual or ice would have a lower base offense level than currently applied in their case. In total, under option 2, when 2 or more factors are required, about 2,800 more individuals would have a lower base offense level than under the current guideline. Last, for option 2, if the Commission were to require 3 or more reducing factors and 3 or more heightening factors, here is how the base offense levels would change from how they were applied in fiscal year 2024. For individuals with methamphetamine mixture, 2% had 3 or more heightening factors and would increase to the meth actual base offense level. 84% did not have at least 3 reducing or heightening factors. Their base offense levels would be set at the cocaine base quantity levels, which are in the middle between meth actual and meth mixture. The remainder had 3 or more reducing factors and would remain at the meth mixture base offense levels. The overall result would be that about 2,100 individuals sentenced at the meth mixture level would have a higher base offense level than currently applied in their case. For individuals with methamphetamine actual or ice, 15% had 3 or more reducing factors and would decrease to the meth mixture base offense level. 83% did not have at least 3 reducing or heightening factors. Their base offense level would be set at the cocaine base quantity levels, which are in the middle between meth actual and meth mixture. The remainder had 3 or more heightening factors and would remain at the meth actual base offense level. The overall result would be that about 5,000 individuals currently set at the meth actual base offense level would have a lower base offense level than currently applied in their case. In total, under option 2, when 3 or more factors applied, this would be a net change of about 2,800 individuals set at a lower base offense level than under the current guideline. This slide summarizes the impact of option 2 using different requirements for the reducing and heightening factors and how it would affect the 1/3 of current cases where the base offense level is set at the methamphetamine mixture level and 2/3 of cases where the base offense level are set at the methamphetamine actual and ice levels. If the Commission were to establish base offense level quantities in between the current meth actual and meth mixture levels and require 1 or more factors to heighten or reduce these levels, the Commission estimates that 2/3 of meth cases would use the meth mixture base offense level and 1/3 would use the actual or ice base offense levels. If the Commission were to require 2 or more reducing and heightening factors, then the Commission estimates that 1/3 of meth cases would use the meth mixture base offense levels, 10% would use the actual or ice base offense levels, and more than half would use the base offense level in the middle between those levels. Finally, if the Commission were to require 3 or more reducing or heightening factors, the Commission estimates that 2% of cases would use the mixture base offense levels, 14% would use the meth actual base offense levels, and 84% would use the base offense levels in the middle between those levels. Next, we'll discuss Part B of the proposed amendment, which would amend Section 2D 1.1 to include fentanyl-related substances. Part B of the proposed amendment would amend Section 2D 1.1 to respond to the enactment of the HALT Fentanyl Act, which permanently scheduled fentanyl-related substances. The proposed amendment would amend the drug quantity table at subsection C of Section 2D 1.1 to add fentanyl-related substances. It would set the quantity threshold and base offense levels for these substances at the same level as fentanyl analogs. In addition, Part B of the proposed amendment would add fentanyl-related substances to the enhancement at Section 2D 1.1 B13 for representing or marketing fentanyl or a fentanyl analog as another substance or legitimately manufactured drug. To help inform Part B of the amendment, we will review data on the number of fentanyl analog trafficking cases broken down by whether the case involved a scheduled or non-scheduled analog. A non-scheduled analog is a substance that would have fallen under a temporary scheduling order and thus would likely qualify as a fentanyl-related substance. Fentanyl analog offenses occupy a small percentage of drug trafficking cases, though a number of cases has increased over the last several years. In 2021, the Commission began gathering information on the type of fentanyl analogs involved in cases, though courts do not always specify the type of analog involved. As a result, in some cases, it is not always possible to determine whether the case involved a scheduled or non-scheduled analog. In fiscal year 2021, 123 fentanyl analog cases were reported to the Commission, which increased to 348 analog cases in 2024. In most fentanyl analog cases reported to the Commission over the past 4 years, the case involved an analog that was permanently scheduled. Between fiscal years 2021 and 2024, there were 20 cases involving a non-scheduled analog that would likely qualify as a fentanyl-related substance. In most of those 20 cases, courts calculated the base offense level by using the converted drug weight for a fentanyl analog. Finally, Part C of the proposed amendment would amend Section 2D 1.1 to add 4 new specific offense characteristics that increase offense levels in fentanyl and fentanyl analog trafficking cases involving certain conduct. The Commission is considering each of these specific offense characteristics individually and whether to promulgate any of these specific offense characteristics or a combination of them. First, Part C of the proposed amendment would add a new specific offense characteristic at Section 2D 1.1 relating to the distribution of fentanyl or a fentanyl analog to an individual less than 18 or 21 years of age, or when the use or attempted use of an individual less than 18 or 21 years of age to commit an offense involving such substance. For this enhancement to apply, the defendant must be, at the time of the offense, at least 4, 6, or 8 years older or substantially older than the individual. Part C brackets alternatives for making the enhancement defendant-based or offense-based. The defendant-based alternative of this enhancement also brackets a mens rea requirement of knowledge relating to the age of the individual and the substance involved in the offense. Second, Part C of the proposed amendment would add new specific offense characteristic at Section 2D 1.1 relating to the use of the dark web or dark nets to facilitate the commission or concealment of an offense involving fentanyl or fentanyl analog. It also brackets alternatives for making the enhancement defendant-based or offense-based. Third, Part C of the proposed amendments would add a new specific offense characteristic at Section 2D 1.1 relating to the distribution of a mixture or substance containing a fentanyl or fentanyl analog and xylazine. It brackets alternatives for making the enhancement defendant-based or offense-based. Fourth, Part C of the proposed amendment would add a new specific offense characteristic at Section 2D 1.1 relating to the use or possession of a tableting machine or encapsulating machine for the purpose of manufacturing fentanyl or a fentanyl analog. It brackets alternatives for making the enhancement defendant-based or offense-based. Commission staff previously conducted a special data collection project to identify the cases that might have been affected by these proposed enhancements. As part of the previously conducted special data collection project, Commission staff only looked at the distribution to individuals less than 21. Thus, the data presented here is limited to distribution. In fiscal year 2023, there were 37 cases in which the offense involved distribution of fentanyl or a fentanyl analog to persons under 21 years old. The average age of the person receiving the drug in these cases ranged from 14 to 21 years old. The base offense level was determined by the drug quantity table in 17 cases, and in an additional 14 cases, the base offense level was determined by one of the alternative levels at Section 2D 1.1, A 1 through 4 for death or bodily injury. The remaining cases were sentenced under Section 2D 1.2 with no reference to the drug quantity table. The most often applied enhancements were the weapons enhancement at Section 2D 1.1 B1, which was applied in 9 cases, the premises enhancement at Section 2D 1.1 B12 in 5 cases, and the violence enhancement at Section 2D 1.1 B2 and the mass marketing enhancement at Section 2D 1.1 B7, each applied in 3 cases. Of cases where the defendant distributed fentanyl or fentanyl analog to a person under 21 years old, most sentenced individuals perform the function of a street-level dealer, selling user quantities of fentanyl or fentanyl analog. In those 37 cases, 41% were sentenced below the guideline range, 32% were sentenced within the guideline range, and 27% were sentenced above the guideline range. The average guideline minimum in these cases was 166 months, and the average sentence imposed was 151 months. Of these cases, 38% of individuals were white, and 1/4 of individuals were Black and Hispanic. Most individuals were male and U.S. citizens. The average age of individuals was 26 years old. The second proposed enhancement is the use of the dark web to facilitate the commission or concealment of the offense. In fiscal year 2023, 60 fentanyl drug trafficking cases involved the use of the dark web or cryptocurrency. Of these cases, most involved the use of both. The enhancements that applied most often in these cases were the mass marketing enhancement at Section 2D 1.1 B7 with 27 cases, misrepresentation of fentanyl enhancement at Section 2D 1.1 B13 in 17 cases, the weapons enhancement at Section 2D 1.1 B1 in 12 cases, and the premises enhancement in Section 2D 1.1 B12 in 11 cases. Of cases where the defendant used the dark web to traffic fentanyl, almost 1/4 of individuals performed the function of a street-level dealer, followed by 16% performing the function of a wholesaler, 14% performing the function of an importer, and 14% performing the function of an employee. Of these 60 cases, 90% were sentenced below the guideline range, 7% were sentenced within the guideline range, and 3% were sentenced above the guideline range. Most individuals who received a sentence below the guideline range received either a Section 5K 1.1 or a Section 5K 3.1 departure. 40% of individuals received safety valve. The average guideline minimum was 155 months, and the average sentence was 84 months. The proposed enhancement would most often apply to individuals who are white, male, and U.S. citizens. The average age of individuals was 34 years old. The third proposed enhancement is the distribution of a mixture or substance containing xylazine. The Commission has asked an issue for comment on whether other adulterants should be included, such as methamphetamine, so information on methamphetamine is included here as well. In fiscal year 2023, 94 cases involve xylazine or methamphetamine as a mixing agent with fentanyl or a fentanyl analog. 90 of these cases involve xylazine as the mixing agent. The most often applied enhancements were the weapons enhancement at Section 2D 1.1 B1 in 37 cases, the premises enhancement at Section 2D 1.1 B12 in 22 cases. all other enhancements were applied in 2 or fewer cases. In cases where the sentenced individual mixed fentanyl or fentanyl analog with xylazine or medetomidine, 38% of individuals performed the function of a street-level dealer, followed by 1/3 performing the function of a wholesaler. Of these cases, 63% of individuals received a sentence below the guideline range, 35% received a sentence within the guideline range, and 2% received a sentence above the guideline range. About 1/5 of sentenced individuals received either a Section 5K 1.1 or a Section 5K 3.1 departure. 20% received safety valve. The average guideline minimum was 110 months, and the average sentence was 81 months. The proposed enhancement would most often apply to individuals that are Black and Hispanic. Most individuals were male and U.S. citizens. Their average age was 39 years old. Finally, the fourth proposed enhancement is the use or possession of a pill press. In fiscal year 2023, 84 cases involved the use of a pill press. Of these cases, 72 cases used the pill press with fentanyl, and 12 used the pill press with a fentanyl analog. The most often applied enhancements in these cases were the weapons enhancement at Section 2D 1.1 B1 in 37 cases, the premises enhancement at Section 2D 1.1 B12 in 26 cases, the misrepresentation of fentanyl enhancement at Section 2D 1.1 B13 in 15 cases, and the mass marketing enhancement at Section 2D 1.1 B7 in 11 cases. In cases where the defendant used a pill press to press fentanyl, 1/3 of individuals performed the function of a wholesaler, and 1/3 of individuals performed the function of a manufacturer. 75% of cases received a sentence below the guideline range, 21% received a sentence within the guideline range, and 4% received a sentence above the guideline range. Almost 1/2 received either a government-sponsored or non-government-sponsored variance, and 1/4 received either a Section 5K 1.1 or a Section 5K 3.1 departure. About 1/3 received safety valve. The average guideline minimum was 152 months, and the average sentence was 100 months. The proposed enhancement would most often apply to individuals that are Black. Most individuals were male and U.S. citizens. Their average age was 36 years old. This concludes the data presentation. For further information on drug trafficking offenses, please visit the United States Sentencing Commission's website at www.ussc.gov. Comments may be submitted to the Commission at the address shown. The public comment period concludes on February 10, 2026.